transcript of the committee's interview with Steve D'Antuono, the former leader of the FBI's Washington field office.
Without objection.
Clearly refutes characterizations that the FBI was involved in inciting violence on January 6th.
Without objection. The gentleman from...
I ask unanimous consent to enter into the record an excerpt from the special agent in charge of the FBI Boston field office, in which he explains that conspiracies about the FBI causing the Capitol insurrection are false and concerning.
Without objection.
And finally, I ask unanimous consent to enter an excerpt from FBI Director Wray's testimony before this committee last July, where he states, quote, I will say this notion that somehow the violence at the Capitol on January 6th was part of some operation orchestrated by FBI sources and agents is ludicrous, and it's a disservice to our brave, hardworking, dedicated men and women. Close quote.
Without objection. The gentleman from the floor is recognized for 5 minutes.
Attorney General, you've told us that it's a dangerous conspiracy theory to allege that the Department of Justice is communicating with these state and local prosecutions against Trump. You can clear it all up for us right now. Will the Department of Justice provide to the committee all documents, all correspondence between the department and Alvin Bragg's office and Fonnie Willis's office and Letitia James's office?
The offices you're referring to are independent offices of state.
I get that. I get that.
State.
The question is whether or not you will provide all of your documents and correspondence. That's the question. I don't need a history lesson.
Well, I'm going to say again, we do not control those offices. They make their own decisions.
The question is whether you communicate with them, not whether you control them. Do you communicate with them, and will you provide those communications?
You make a request. We'll refer it to our Office of Legislative Affairs.
But see, here's the thing. You come in here and you lodge this attack that it's a conspiracy theory, that there is coordinated lawfare against Trump. And then when we say, fine, just give us the documents, give us the correspondence, and then if it's a conspiracy theory, that will be evident. But when you say, well, we'll take your request, and then we'll sort of work it through the DOJ's accommodation process, then you're actually advancing the very dangerous conspiracy theory that you're concerned about. Now, you were a judge, once nominated the highest court in our country. When you were a judge, I'm just curious, did you ever make political donations to partisan candidates?
No.
No, and you didn't, because that would create the potential appearance of impropriety.
I didn't, because there's a federal rule barring federal judges from making contributions.
Right, but under that same theory of attacks on the judicial process, like, shouldn't someone be owed like a jury of their peers and a judge that's non-biased rather than getting a judge from your political opponent's donor file?
I'm well aware that you're not asking a hypothetical. You're asking me to comment on a jury verdict in another jurisdiction which has to be respected. I won't comment on it. That case is still ongoing. The defendant
Mr. Attorney General, I hadn't asked you about the verdict yet. We were getting there. I was talking about the judge. And so let me ask you this question about your time as a judge. Was there ever a time when you were a judge when you had a family member who was personally profiting off of the notoriety of a case that was before your court?
Look, I'm going to say again, it's very clear you're asking me to comment on a case in another jurisdiction.
No, wait, hold on, Mr. Attorney General. Did you ever have a family member profit off of the notoriety of any case that you sat over?
Say again, you're asking
yes or no?
You're asking me to comment on a case currently.
Well, it seems you're connecting the dots,
court.
Mr. Attorney General. I'm just asking you as to a general principle, but you are aware that Judge Merchan's daughter was profiting off of this prosecution. You are aware that the reason there's a federal rule against judges giving donations is because it is the very attack on the judicial process that we're concerned about.
I'm sorry, I don't agree with anything you just said, but I'm not going to comment on it.
Okay, so you won't comment on it, Mr. Attorney General, but you had no problem dispatching Matthew Colangelo. Who's Matthew Colangelo?
That is false. I did not dispatch Matthew Colangelo.
Matthew Colangelo became the Assistant Attorney General at the very beginning of the Biden administration. Without having been Senate confirmed, goes and gets the senior role at the DOJ, and then after, I believe it's Gupta replaces Colangelo, Colangelo makes this remarkable downstream career journey from the U.S. Department of Justice in Washington, D.C., and then pops up in Alvin Bragg's office to go get Trump. And you're saying that's just a career choice that was made that has nothing to do with the lawfare coordinated by the DOJ.
I'm saying it's false. I did not dispatch Mr. Colangelo anywhere.
Well, do you know how he ended up there?
I assume he he applied for a job there and got the job.
But see, you know what?
I can tell you I had nothing to do with it.
Well, you might not have had anything to do with it, but we've got this contemporaneous evidence in Mr. Pomerantz's book. So Pomerantz writes this book, which I'm sure you're aware of, where he says, we put together the legal eagles to get Trump. We got all these folks together, and we assembled them for that purpose. And so when we on the Judiciary Committee think about attacks on the judicial process, our concern is that the facts and the law aren't being followed. A target is acquired, here, Trump, and then you assemble the legal talent from DOJ, Mr. Pomerantz, and you bring everybody in to get him. And meanwhile, the judge is making money on it. The judge is making money on it, or the judge's family is making money on it for stuff that you yourself wouldn't do. You know, no one's going to buy this. No one's going to believe it. It's going to create great disruption. And I am saddened by it because, like you, I have given my life to the law. I care deeply about the law, and I think that the lawfare we've seen against President Trump will do great damage well beyond our time in public service. I see my time's expired. I yield back.
Ranking members recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, do you want to respond to anything in Mr. GAETZ's tirade?
I think everything he was talking about was a case in another jurisdiction, an independent prosecutor. Mr. Pomerantz worked for that independent prosecutor. I don't know Mr. Pomerantz. I don't know what's in his book, but these are decisions made in another office independent of the Justice Department.
Thank you, Mr. Attorney General. Last week, as we all know, a jury of his peers convicted former President Trump on 34 felony counts of falsifying business records of the first degree. The case was brought by the Manhattan DA, so it is a state case, not a federal case. I shouldn't have to ask you this, Mr. Attorney General, but since the majority seems to be confused, can you please explain the difference between a state case and a federal case?
Yes, the Manhattan District Attorney has jurisdiction over cases involving New York state law, completely independent of the Justice Department, which has jurisdiction over cases involving federal law. We do not control the Manhattan District Attorney. Manhattan District Attorney does not report to us. The Manhattan District Attorney makes its own decisions about cases that he wants to bring under his state law.
Thank you. My Republican colleagues seem to believe that the Department of Justice is secretly coordinating the now successful prosecution of former President Trump in New York. Is there any truth to this allegation? And what is your response to this allegation?
The case in New York is brought by the Manhattan District Attorney independently on his own volition and on his own determination of what he believed was a violation of state law.
Mr. Attorney General, 2 weeks ago, this committee took the extraordinary step of holding you in contempt. I want to make some things clear for the record. Since 2022, when the chairman took over the committee, the Department of Justice has produced over 92,000 pages of documents and made 25 employees available for interviews. We've run the numbers. This is more than double the number of documents and exponentially more witnesses than the Trump administration's Department of Justice produced to this committee in 4 years. And with respect to the actual audio recordings sought by the majority, the Department of Justice has produced full and complete transcripts of the conversations memorialized by these recordings. Is that correct?
It is.
There's been an allegation that the transcripts might have been altered in some way. Is there any truth to that allegation?
There's no truth to that. The senior career official in the department, in a declaration he filed under oath, stated that he had compared the audio to the transcript, and that it is an accurate, transcript is accurate with the exceptions of us and ahs and repetitions of words like I and and. And he consulted with Mr. Hur, the special counsel, and with the FBI agents in the room who agreed, who created the transcript and who agreed that it was an accurate transcript.
Thank you. One more question. Mr. Attorney General, throughout the 118th Congress, Republicans have made bogus allegations claiming that the Justice Department has been weaponized. Most recently, there was an allegation that the FBI was authorized to, quote, kill the former president. What impact does this type of rhetoric have on the career prosecutors and law enforcement agents at the Department of Justice?
This is dangerous. It raises the threats of violence against prosecutors and career agents. The allegation is false. As the FBI has explained, the document that's being discussed is our standard use of force protocol, which is a limitation on the use of force and which is routinely part of the package for search warrants and was part of the package for the search of President Biden's home as well.
So when former President Trump alleges that this was an assassination attempt against him, he is not telling the truth, either knowingly or, as is often the case with him, unknowingly.
I'm just saying that the allegation is not true. This is our standard use of force policy, which limits the use of force that agents can use. It is used as a routine matter in searches. That was a court-authorized search, and it accompanied that package as it routinely does.
Thank you. So in other words, when former President Trump makes that allegation, he is either deliberately or, as is often the case, not knowing what he's either deliberately lying or, as is often the case, not knowing what he's talking about. Thank you. I yield back.
And Hunter Biden, while simultaneously spinning webs of lies that seek to create public wrath against anyone who would dare to be involved in any effort to hold the convicted felon Donald Trump accountable for his misconduct. The American people can see right through these distraction efforts. Attorney General Garland, thank you for your many years of service to our nation. Among other positions in the federal justice system, you have had an illustrious career as a federal judge, a judge of the United States Court of Appeals for the District of Columbia Circuit from 1997 through 2021, including as chief judge from 2013 to 2020. And you also served as chair of the Executive Committee of the Judicial Conference of the United States from 2017 to 2020. So I'm sure that you've had a lot of time to think deeply about the importance of judicial impartiality in a functioning democracy. I and 44 other members of Congress have called for Justices Thomas and Alito to recuse themselves in cases where they cannot be seen as impartial in the case seeking immunity for Donald Trump and others. Justice Thomas's wife played a major role in the Stop the Steal movement that culminated in the January 6th insurrection, and we recently learned that Justice Alito flew flags related to the Stop the Steal movement at both his residential home and his vacation home in 2021 and again in 2023, which directly ties him to the January 6th insurrection, to Donald Trump, and to efforts to overturn the 2020 election. We urged them to recuse themselves from related cases, and Justice Alito last week refused. Then last week, my colleague Jamie Raskin wrote an op-ed arguing that DOJ could petition the other 7 justices to require Justice Alito and Thomas to recuse themselves. That leads me to this question. Is the filing of such a petition with the Supreme Court something that the Department of Justice is considering?
I'm afraid I'm going to have to give you the same answer I've given to other members. The Justice Department can't comment on matters that are before a court, matters you're talking about before the Supreme Court.
This is, I'm talking in terms of an independent petition, not related to any matter pending before the court at this time, but related to those matters.
Justice Department speaks through its filings on matters before the court, and that's all I can say about it.
Well, I'd like for the DOJ to at least consider that possibility. My next question, public reporting has revealed that Supreme Court Justices Clarence Thomas and Samuel Alito have accepted gifts of luxury travel and lodging from billionaire benefactors and failed to report those gifts as required under federal financial disclosure laws. The Ethics in Government Act provides the Attorney General authority to investigate and take action against violations of the financial disclosure laws by members of the federal judiciary. even without a referral from the Judicial Conference. What can you tell us about Department of Justice efforts to investigate those high-profile violations by those two justices?
I'm afraid I'm going to have to say the same. As I said before, the Justice Department does not comment on whether it investigates or who it investigates or whether it should investigate.
Fair enough,
All of
sir.
our statements are reflected in court papers. And
Fair enough. Threats on the judiciary are increasing, and this is frightening to the rule of law. Can you talk about the work that DOJ is doing to address this important issue?
Yes, the threats to the judiciary, threats to prosecutors, threats to law enforcement agents have all spiked significantly, and in some cases have accelerated from threats to actual violence. We have a threats task force engaged in investigating these matters. We intend to aggressively investigate and prosecute threats against our public officials, including members of Congress, of which the numbers have actually exploded in the past couple of years. Our democracy cannot continue if the people who make the democracy run are afraid, if they make their decisions based on fear of being threatened or of being assaulted. No democracy can survive under those circumstances, and we will do everything we can in our power to investigate, deter, and prosecute anyone who makes threats against public servants.
Time of the gentleman.
Thank you. I yield back.
Gentleman yields back. Mr. Garland, why Jack Smith? Why'd you pick him?
I've said at the time I appointed Mr. Smith, I explained he was independent. He was a longtime career prosecutor
But there are probably other people who you would describe as independent, long-time career prosecutor. Why did you pick, this is probably the most high-profile special counsel investigation, maybe in American history. You're going to be investigating a former president, a candidate for president, and leading in all the polls, and you pick Jack Smith. Most important selection maybe ever made from Attorney General when you come to a special counsel. I just want to know why you could have picked former AGs, deputy AGs, U.S. attorneys. You got all kinds of lawyers in this town, but you picked Jack Smith.
All the people you just mentioned would be political appointees. I appointed somebody who was not a political appointee, somebody who was independent, nonpartisan, with a record of career experience as a prosecutor. That seemed to me the perfect resume for making that kind of.
He was a guy, worked, had to bring him back from Europe. He worked at the ICC, worked at the World Court. He was the best pick for the most high-profile investigation ever.
He was independent. He was nonpartisan. He had never held a political office. He was never appointed in a political office.
Was he your first choice?
He had a long career as a career prosecutor.
Was he your first choice?
I'm not going to go into the questions.
Did you know him before you picked him?
I did not.
You never worked with him?
I did not.
Did you meet with him prior to announcing his selection and tell him what was going on?
Of course I did.
What happened in that meeting?
I met with him. I asked him if he would be willing to do this. We talked about my understandings of the role of this office, which are on the public record. That's all.
Did he ask for the job?
This is not a job I don't think anybody asks for. I'm sorry.
No, but that's not the question I asked you. I said, did Jack Smith ask for the job?
He did not ask me for the job, no.
Did he convey through someone else that he wanted the job?
I would be surprised if that were the case, but
But you don't know?
No, I don't know.
So he may have?
I can only tell you what I know. I chose him because he had a record of impartial career experience as a prosecutor. That's why he was chosen.
Was it impartial when he went after Governor McDonnell?
He was a member of
He was after Governor McDonnell. That case gets appealed to the Supreme Court. The Supreme Court unanimously said it was wrong and overturns the conviction?
He was in the public integrity section of the Justice Department, a career position. They made the decisions they thought were warranted, and we respect the decision of the Supreme Court.
Did the fact that he was interested in going after the very people who were targeted by the IRS about a decade ago, did that have any influence on your selection? Okay, let's put up this slide here. This is from Jack Smith to some other folks in the Justice Department, and it says, could we ever charge a conspiracy to violate laws of the U.S. for misuse of such nonprofits to get around existing campaign finance laws? Jack Smith was looking to prosecute the very people who were targeted by the Obama IRS.
I don't know. You have excerpts from an email I've never seen. You should know that
IRS
I sat...
Commissioner Sarah, I'm just asking, did this weigh into your decision? Did you know about this?
No,
what
no,
Jack Smith
I
was
don't
trying
know
to
if
do?
it's... I also don't know if it's true now.
IRS Commissioner Sarah Ingram oversees this from Jack Smith himself. Let's discuss tomorrow, but maybe we should try to set up a meeting this week. And here's the response. Here's the response. You didn't get your meeting with Miss Ingram from the IRS, but she's sending the head of the exempt organizations, Lois Lerner, who's known to us. So Jack Smith meeting with Lois Lerner, looking for ways to prosecute the very people who were victims of the Obama IRS. And I'm just asking, did that factor in your decision to name Jack Smith as special counsel?
I didn't have any idea about the things...
Didn't know about that?
No, and I don't know whether they're true now by looking at this.
Well, they're definitely true, but you didn't
should
know about
know.
it. But this guy was so important, you have to bring him from Europe back here to go after President Trump, name him as a special counsel. Do you regret the pick?
I'm sorry, I couldn't...
Do you regret picking him?
No, I do not regret picking him.
Well, prosecutors aren't supposed to tamper with evidence, and it looks like that's what he did. He changed the sequence of the documents that he seized from Mar-a-Lago.
I'm sorry, that's a false characterization, but that is ongoing.
Here's what he said to the court, Mr. Attorney General. There are some boxes where the order of items within the box is not the same as in the associated scans. I mean, he said it. I didn't say it. He told the court that.
Now you're asking me to comment on a discovery dispute that's ongoing in a court. I don't know the facts of it, and I'm not going to comment on it.
No, this is from Jack Smith filing with the court. He admitted to the court that they tampered with the evidence. He mishandled the very documents he's charging President Trump with mishandling. And I'm just asking, do you regret picking this guy as the special counsel in the most important special counsel investigation probably in American history?
I'm sorry, I did not hear the words tamper in the statement that Mr. Smith filed. He did not use those words.
Well, let me ask it this way. Are you supposed to change the order of the documents that you seize and the physical documents don't match up with the scanned documents? Are you supposed to do that as a prosecutor?
This is a matter in dispute, in discovery, in that court, and I'm going to leave it for the district court to make a determination. After
I would just say one last thing. It's not in dispute. This is what he said in the court filing. Jack Smith's team said that to the judge in the court. By the way, this case is now basically on hold because they've screwed up so many things.
Again, I don't know whether your description of the facts are true or not true, and I'm not going to intrude in a decision in a district court.
Chair recognizes the gentleman from California.
Mr. Attorney General, we appreciate your being here. We appreciate how you have led this department with integrity and discipline and your enormous public service. I appreciate your willingness to sit through this endless cascade of false allegations and conspiracy theories and innuendo. The chairman began this hearing with the dramatic statement that justice is no longer blind. By that, he means that justice is no longer objective or impartial, that it is suddenly now a respecter of persons in the wrong way. That is, it will distinguish between people based on their position. But of course, the chairman's real problem is that justice remains no respecter of persons. That you can be the former president of the United States, but if you commit crimes, you'll be held responsible. That's his problem. That's the problem of all my Republican colleagues right now, and that is they're about to nominate a convicted felon. And they don't know how to cope with that. They don't know how to cope with the justice system that, in fact, treats Donald Trump the same as it would any other citizen. And so they have to push these conspiracy theories that they know are patently false. And they try to run over you with questions they won't let you answer, because their whole arguments are utterly insupportable and destructive of our justice system. They care more about this convicted felon than they do the country. I have to say I'm pleased and a bit surprised to see that the flag in this committee is still flying right side up, because they want to turn it upside down, even as they want to turn our justice system upside down. Let me address the conspiracy theory of the day, which is somehow President Biden, through your department, has convicted Donald Trump in Manhattan in an effort to weaponize justice against the former president. So let me just ask some basic questions about this phony conspiracy theory. Did you appoint Alvin Bragg to be Manhattan DA?
No.
Of course not. He's elected. Did you select the jury in that case?
The judge selected the jury.
Well, did you select the judge in that case?
No.
No, of course not. The judge was randomly selected. Did you select the jury in that case?
No.
The jury was actually selected by Donald Trump and his attorneys. Did you reach a verdict in that case?
No.
Did you instruct the jury in that case?
No.
Did you tell the prosecutor what charges to bring in that case?
No.
This was 12 ordinary New Yorkers who weighed the evidence and found Donald Trump guilty of 34 felonies. And instead of celebrating the fact that in this country, an ordinary group of jurors, an ordinary group of 12 people can still adjudicate a case involving one of the most powerful people in the country, no, they would denigrate the whole system. They would tear it down. In the service of this convicted felon, they would tear everything down. They would tear the house of this democracy down around them. They say it's unprecedented to bring charges against a former president. You're damn right it's unprecedented. We've never had a president of the United States who was making hush money payments to a porn star and then falsifying business records to cover it up. Yeah, that's unprecedented. We've never had a president withhold classified information and then obstruct the investigation. That is unprecedented. We've never had a president incite a violent attack on the Capitol. That is unprecedented. And you know what else is unprecedented? The fact that so many leaders of that party are perfectly fine with all of that. In their headlong pursuit of power, they're perfectly fine with that. They're going to nominate a convicted felon as their presidential candidate. And they have another conspiracy theory, which is when a search was executed of the president's residence in Mar-a-Lago, they went in, as the president said, locked and loaded and ready to take him out. Yet another dangerous falsehood. And your dedicated public servants at the Justice Department are having their lives threatened because of the irresponsible actions of people on this committee and in the Senate and elsewhere who would endanger the lives of those committed to enforcing law and order, even as they claim to be a party of law and order. Mr. Attorney General, I am grateful for your service, for your withstanding all of this. We will get through this because of people like you and the honorable public servants at the Justice Department. Mr. Chairman, I yield back.
Gentleman yields back. The chair recognizes the gentleman from Arizona.
Thanks, Mr. Chairman. Mr. Attorney General, the reality is Mr. Hur, Special Counsel Hur, found that then former Vice President, President Biden, had retained and disclosed classified information. Isn't that true?
Mr. Hur has presented a long report.
Isn't that true? I mean, come on. I'm practically quoting right from it. You wouldn't disagree with that assessment?
I won't disagree with I'm not going to comment on his report. He sets forth. I appointed him to investigate the allegations about classified documents.
So the reason that we end up talking over you is because a simple question like that goes unanswered. You're non-responsive. You're non-responsive to the question. Because that is what Mr. Hur found. And then he also found, and you're not going to like this because I'm going to quote from it. From this, he basically says here that he found Mr. Biden to be sympathetic and here he is, a well-meaning elderly man with a poor memory. And so he made a prosecutorial decision that he wasn't going to prosecute. Are you going to dispute that? You're not disputing that, are you?
Mr. Hur's report.
Okay, you're going to say it stands on its own. Okay, so it stands on its own. No, because you're not intent on answering. You want to be non-responsive. You want to filibuster.
I'd like to answer your question.
Do you dispute that? So let's just face it. Mr. Biden has not been prosecuted, correct?
That's correct.
And the rationale given by Mr. Hur is because he was a sympathetic, well-meaning elderly man with a poor memory, and he thought the jury would have sympathy towards Mr. Biden.
That was one of a long list of reasons that Mr. Hur gave for his decision.
Give me one more reason.
He found that, look, I don't want to get into a discussion about this, but I will say one of them was that the president was completely cooperative in this matter.
That's the reason, huh? Okay, all right.
You asked me one of the reasons. That was one of the reasons.
The issue that we have here, you don't want to give us the audio tape. You don't want us to have the recording. But ultimately, the issue is whether the transcript actually supports the special counsel's determination. Now, your office has basically pled two things in court, claiming, number one, executive privilege, and number two, this kind of interesting novel approach saying deep fakes, AI. Right. Did they consult, did your staffer who filed that, did they consult with you about the deep fake AI rationale for not providing the audio to us?
You're mischaracterizing the filing. That was one of a substantial number of arguments made in a Freedom of Information.
Did they consult with you specifically about that idea, that notion where they were going to say something like, quote, this is from the pleading, the passage of time and advancements in audio, artificial intelligence, and deepfake technologies only amplify concerns about malicious manipulation of audio files, close quote. Did they consult with you about that provision?
I'm not going to talk about internal department deliberations. That was one of a large number of explanations in the document you're talking about.
And I'm talking specifically about that particularized rationale. And you don't want to discuss it, which is why you're non-responsive, and that's why we need the audio. Now, let me explain why. Because your attorney also said that you did alter the transcript, and they said it was filler words, repeat words, and, I. But you know what? We don't know whether the blank, he said there were blank times where there was silence. We don't know whether those were 1 minute long, 2 minutes long. We don't know if he sputtered for and, because those were edited out. We do not know whether this supports and substantiates Mr. Herr's findings. By the way, you want to rely on Mr. Herr, you need to go back and listen to his testimony. Mr. Herr was pretty conclusive there that he had a poor memory. He was not able to answer all the questions. Substantively, the transcript may be accurate, but you know what? The audio would tell us so much more, which is why the Supreme Court, in the case that you poo-pooed when Mr. Fitzgerald was asking about, they said, look, you know, if there's editing that's gone on here, that's the rationale, and there was editing. Your own office admitted it, but you won't admit it today. You've been non-responsive, and that's why we need the audio, and that's why you're here. Yield back.
Gentleman yields back.
Mr. Chairman, I have a unanimous consent request.
Ranking members recognized.
Mr. Chairman, I ask unanimous consent to enter into the record the transcripts of Special Counsel Herr's interviews with President Biden. As you can see on the last pages, the transcriber certifies that the transcripts are true and correct.
Objection. The gentleman from Arizona is recognized for unanimous consent.
Thank you, Mr. Chairman. I also submit the pleadings in the case of Judicial Watch versus U.S. Department of Justice.
Objection.
A document entitled DOJ Claims Unprecedented Deep Fake.
Objection.
Transcript tampering. DOJ says written record of Biden interview with prosecutors omitted words.
Objection.
DOJ refuses to release audio of Biden and the Herr interview.
Objection. The gentleman from California is recognized.
Before anyone else on the other side saddles up and gets on their high legal horses, I just want to remind the committee that the chairman is 754 days into his own subpoena defiance. Mr. Attorney General, last week it was reported that House Ethics Panel subpoenas DOJ for GAETZ records. It was a May 14, 2024 political piece. I'd like to submit it to the record with unanimous consent.
Without objection.
I just want to get this straight. Mr. GAETZ wants the Attorney General to reopen and publicize evidence from an investigation that a Donald Trump-appointed prosecutor closed against President Biden, while at the same time, Mr. GAETZ himself is being protected by the same DOJ policy that is refusing to voluntarily turn over evidence from Mr. Gates' sex trafficking investigation. Mr. Attorney General, can you just briefly, without going into the facts of that case, address why that is the DOJ policy as it relates to the current president and any other requests about closed investigations?
Yeah, without referencing any case, we try to protect the law enforcement files of the Justice Department so that in future investigations, people are willing to cooperate with us. We understand Congress's concerns and we have an obligation to assess whether the information that we've provided is sufficient to accommodate the legitimate needs of the Congress. All of the reasons that Congress has given us for why they need the audio are satisfied with respect to the tapes. That is, all of the legitimate reasons given, the reasons that relate to legislative work of the committee. As to that, we've accommodated by providing the audio. We provided Mr. Herr's testimony in full, and we've provided Mr. Herr's testimony report. We've gone as far as we can go to accommodate. We're trying to protect our ability to do investigations in this case and in any other case.
Mr. Attorney General, let's set the facts straight here. And my job is to kind of lead an intervention for my colleagues. I think they need it. The Attorney General did not prosecute Donald Trump in New York. It was the result of Donald Trump's choices. Donald Trump chose to live in New York. He chose to commit his crimes in New York. He was afforded a right to be tried by his neighbors, jurors, in New York. He chose that jury in New York, working with his counsel, and they chose to make him a 34-time over convicted felon. But some of the choices the department has made in the recent years is that the president that was first appointed, that Donald Trump appointed the U.S. attorney who is investigating the current president's son. Donald Trump appointed John Durham, who investigated the wild claims made by this committee during the Russia investigation. And Donald Trump appointed Robert Hur, who was kept on by the Biden administration. Also, you have the right in our country to aid yourself in your own defense and talk to investigators. You also have a right not to. Mr. Attorney General, did Donald Trump sit down for an interview in the Mueller investigation?
I actually don't know, but I'm not going to comment on other investigations.
He didn't. Did he sit down for an interview with investigators prior to the January 6th indictment?
I'm not going to comment on it.
He didn't. He also didn't sit down for an interview with investigators in the classified materials indictment, but President Biden did sit down for a voluntary interview with Robert Hur. A jury can't hold it against Donald Trump that he did not testify in his own defense in New York, but he promised everyone else in the country that he would. You can hold it against Donald Trump that he did not testify when you consider whether you should so blindly follow every wild claim that he makes. My colleagues, none of this today that you are bringing makes sense. Your inconsistencies, your hypocrisy, your sycophancy, unless you are in a cult. And guys, I'm starting to think you're in a cult. That is your right, but it's not your responsibility. I promise you that's not what your constituents would want. So if you believe in states' rights, except when a jury in that state convicts your nominee for president, you might be in a cult. If you claim you back the blue but want to defund the police when the police go to your nominee's house to retrieve national security secrets, you might be in a cult. If you're supporting a guy whose felony convictions prevent him from getting a security clearance, you might be in a cult. And if the guy you're supporting for president has felony convictions that prevent him from going to Argentina, Australia, Brazil, Cambodia, Canada, Chile, China, Cuba, Dominican Republic, Egypt, Ethiopia, Hong Kong,
my motion
India,
takes precedent.
Indonesia, Iran, Ireland, Israel, Japan, Kenya, Macau, Malaysia, Mexico.
Thank you, Mr. Chairman. The House Judiciary Committee is responsible for helping to ensure the rule of law. Unfortunately, the chairman of this committee himself ignored a bipartisan congressional subpoena. The actions of this chairman have made it harder for congressional committees to get information from witnesses and have hurt the rule of law. Thank you, Attorney General Garland, for your public service. I'm going to ask you a series of simple questions about past concluded cases to get the facts out to American people. The Department of Justice charged Donald Trump's former campaign chairman, Paul Manafort, in a federal court with multiple felonies. Mr. Manafort was convicted in a federal court, correct?
It's my recollection of what the public record discloses.
Public record shows he was convicted in a federal court. The Department of Justice charged Donald Trump's former deputy campaign chairman, Rick Gates, with multiple felonies. Mr. Gates was convicted in a federal court, correct?
Again, that's to To my recollection, that's what the public record discloses.
Thank you. The Department of Justice charged Donald Trump's former campaign foreign policy advisor, George Papadopoulos. Mr. Papadopoulos was convicted in federal court, correct?
Again, that's my best recollection of the public record.
You were not the Attorney General at the time, correct?
I was not, no.
In fact, the Attorney General for those 3 criminal cases was Jeff Sessions, who was nominated by Donald Trump. The Department of Justice charged Donald Trump's former lawyer, Michael Cohen, with multiple felonies. He was convicted in a federal court, correct?
Again, that's my best recollection of the public record.
You were not the Attorney General at the time, correct?
I was not.
In fact, Michael Cohen had 2 sets of convictions. The Attorney General for Michael Cohen's second conviction was Matthew Whitaker, who was also appointed by Donald Trump. The Department of Justice charged Roger Stone, who was an advisor to Donald Trump, with multiple felonies. Roger Stone was convicted in a federal court, correct?
Again, my best recollection of the public record.
Yeah. The Department of Justice charged Elliot Brady, who was a fundraiser for Donald Trump. Mr. Brady was convicted in a federal court, correct?
Same answer.
You were not the Attorney General at the time, right?
I was not.
Okay. In fact, the Attorney General for those 2 criminal cases was Bill Barr, who was nominated by Donald Trump. What these facts show is that the Department of Justice has not been weaponized. We have one Department of Justice that goes after criminals regardless of party affiliation. These Trump associates were convicted under the administration of 3 Republican attorneys general, each of whom was nominated by Donald Trump. Trump's campaign manager, felon. Trump's deputy campaign manager, felon. Trump's foreign policy advisor, felon. Trump's lawyer, felon. Trump's political advisor, felon. Trump's fundraiser, felon. It is not the fault of the Department of Justice that Donald Trump surrounded himself with criminals. Trump brought that upon himself. One of the things that makes America great is we are ruled by the law, not by a cult of personality. I want to thank you, Attorney General Garland and the Department of Justice, for applying the law without fear or favoritism. And I note as we sit here today, the Department of Justice is prosecuting Hunter Biden in a federal court right now. You can't love your country only when the candidate you like wins, and you can't love law and order except when the criminal felon is someone you like. In America, no one is above the law, not the rich, not the powerful, not any former presidents, and certainly none of his criminal felon enablers. Now I want to move on to another subject. Our gentleman from Arizona on the other side of the aisle gave away the game today when he said why he wanted the audio transcript. He said, we wouldn't know if Joe Biden had said and. So I just want to ask you this question. Special Counsel Robert Hur said that this transcript was accurate. The written transcript was an accurate rendition of the audio transcript, correct? Except for some stutters.
Yes.
Okay. So what the gentleman from Arizona wants is that transcript audio with the and. Because Joe Biden stutters. He's had a stuttering problem his entire life. He overcame stuttering. He was made fun of in school, and he overcame this disability to become president of the United States, a leader of the free world. And it is despicable that my Republican colleagues want to go after him for his stuttering problem. They should apologize, and I yield back.
Gentleman yields back. The gentleman from North Carolina is recognized.
Mr. Attorney General, you said earlier today you...
of the Department of Justice, then say that one man is responsible for his behaviors and is being held to account, both civilly and now criminally. Mr. Trump's behaviors are the reasons they are railing and they are upset. He's been found guilty of fraud. He's been convicted on 34 felony counts. And it would be okay if it weren't so dangerous. That's what worries me. It is so dangerous what is going on. So let's be clear. One of the reasons that you're here today is to say somehow the Department of Justice had something to do with the Manhattan District Attorney bringing the suit and a jury of 12 citizen strangers listening to the evidence, hearing from talented prosecutors and defense attorneys and the judge. And they came back with a clarity of 34 convictions for a former president and a presidential nominee. What role did your department have in that prosecution?
That prosecution was determined by the Manhattan District Attorney, which does not report to us, is not controlled by us, and operates completely independent of the Department of Justice.
Thank you. I also want to respond to a few other dangerous statements. Chairman Jordan said a kangaroo court, that's quoting, convicted President Trump. He's the chairman of the Judiciary Committee. Speaker Johnson's claimed that Democrats cheered this purely political exercise, and we heard him in an interview on Fox saying the Supreme Court should break up the conviction, overturn the conviction, and he knows many of the justices personally. Mr. Trump pities himself as a so-called political prisoner. These statements are false, and they are aimed to mislead. They are aimed to inflame. They are dangerous. The nominee is a convicted felon, or the would-be nominee is a convicted felon. What happened is he was guilty of an unlawful conspiracy to win the 2016 election by falsifying records to cover a tryst with a porn star in the days before the 2016 election. I'm grateful our institution stood up. I'm grateful to that set of jurors who walked in as strangers and citizens and listened to the evidence and put the law attached to it. But I'm really deeply concerned that our institutions are under attack. Mr. Garland, you talked about in your written testimony the role of the Department of Justice in upholding the rule of law. Can you speak to that a little more?
So I have devoted my entire career to ensuring that the rule of law is the rule that the Justice Department applies and that the courts apply, that we follow the precedents, that we treat like cases alike, that we do not have enemies or friends, that we do not pay attention to the political parties or the wealth or the power or the influence of the people that we are investigating, that we follow the facts and the law. This is what distinguishes this country from our adversaries. And an attack on the rule of law tears down people's confidence in the basic fundamental element of our democracy, that all people will be treated equal. And I intend to continue to protect the rule of law, to protect the 115,000 career employees of my department, to make sure that they can continue to go about their job, which is to do the right thing every day and not to be distracted by outside influences, political or otherwise.
I thank you, Mr. Attorney General, and I call upon those...
Gentlelady's time.
I want to just mention one other thing.
Quickly.
I'm fearful for the appalling silence of good people on this committee.
Okay.
We've heard enough.
Gentlelady's time has expired. Mr. Attorney General, we understand you want to break. Can we do one more 5 minutes, and then we'll take a little break? Would that work? All right, the gentleman from Texas is recognized.
Thank you, Mr. Attorney General, for appearing before the Judiciary Committee. I read a report recently that the D.C. United States Attorney's Office had only devoted 5% of resources to January 6th prosecutions. But I've also understand from many conversations that the most or all of the United States U.S. Attorney districts contributed an AUSA or an investigator to the effort. Can you confirm whether the department across the board has been providing additional support from other U.S. Attorney's offices in terms of AUSAs or investigators contributing for the January 6th investigations?
Yes, that's true, and that began before I became Attorney General. That continued after I became Attorney General.
So multiple resources across the department have been devoted to that effort, including other districts?
Yes,
okay.
Because of the significance of an attack on democracy in this body.
The reason I'm asking about that is in terms of the focus of the resources of the department. If staff would put up on the screen, there's a number of people here that I want to see if you can identify who they are. What we have here in the bottom right-hand corner is a woman named Lizbeth Medina. She was found dead in a bathtub in Texas. Her mom found her, hoping to see her in a parade that night. She was killed by Rafael Gobea Romero, who was here illegally. On the bottom left-hand corner, you have Lake and Riley. She was killed by 26-year-old Jose Ibarra, arrested by U.S. Customs and Border Protection after he unlawfully entered the United States near El Paso, Texas. Up above, you have officers Richard Yaruso, 26, and Officer Christopher Abreu, 26. Both were shot this last weekend by Bernardo Raul Castro Mata, a 19-year-old Venezuelan national apprehended by U.S. Border Patrol after he unlawfully entered the United States near Eagle Pass in July of 2023. What we have is a continued effort by the federal government to fail to secure the border of the United States, and Americans are dying or getting shot. In this case, law enforcement getting shot, 2 young women who are dead. My question for you with respect to the department is, do you believe that Texas has a right to defend itself and to ensure that people who are in this country are not here illegally, and that we can protect the citizens of Texas from people unlawfully here who are committing crimes to Lisbeth Medina, who's no longer with us because the federal government refused to do its job? Yet the Department of Justice is suing the state of Texas to stop implementation of SB 4. So do you say, as the Attorney General of the United States, Texas does not have a right to defend itself and to protect our citizens from murder by people who have come here illegally into the United States?
I say, as the Attorney General and as a human being, that my heart goes out to the families, that these are terrible, terrible events. And I say, secondly, as the Attorney General, the way to stop people like this from coming into the United States is to give more resources to the Border Patrol so that they can prevent...
Mr. Attorney General, no. No.
You don't want
we the people of Texas, money's not going to solve the problem when the Department of Homeland Security and the President of the United States refuse to enforce the law, ignore the policies, and Lisbeth Medina would be here alive today if we were following the law. Lake and Riley would be here today if we had not released a killer onto the streets of the United States of America through parole policies that this administration is advancing. And the Department of Justice is suing the state of Texas in court, taking valuable resources to go against the people of Texas, when Texas simply wants to say that we should have a say in stopping illegally, arrest them, and be able to deal with that on our own terms when the federal government refuses to do its job.
As reflected in our filings in that case, we are in court because the United States Supreme Court in Arizona versus the United States held that states cannot adopt their own immigration.
You're in court because you're choosing to try to stop Texas from enforcing the laws that the federal government is refusing to enforce. And by the way, that's not the same thing as Arizona. But a final question in my last minute. The Department of Justice did not assert privilege with regard to the transcript, correct?
That's right.
And you articulated a minute ago to my colleague that the best evidence rule says that the transcribed copy is admissible, right? But how can you claim privilege in the face of not just a legislative inquiry, but a constitutional impeachment inquiry? How can you claim privilege for something that you just testified was effectively the same thing? How can you claim privilege for the audio of the transcript you just testified was the same?
I just testified the words are the same. Sensing an audio is different. You have not given any explanation, and there's nothing in the impeachment resolution that would make a difference with respect to audio.
I respectfully disagree. I would ask you one last question. Is the decision not to prosecute President Biden for effectively the same crime for which DOJ is prosecuting President Trump, is it because DOJ has determined the president is not mentally fit to defend himself and stand trial for his crime, but former President Trump is?
I say again, that's an inaccurate description of Mr. Herr's report, and I would rest on Mr. Herr's report.
It's the only assertion he made. I yield back.
Gentleman yields back. The committee will take a short break, and then we'll be back in 10 minutes, 5-10 minutes.
Directly in line with what was just being asked about, Chairman Jordan has argued that the committee needs this audio file of the President Biden's interview with DOJ, yet has refused to release the transcripts from the vast majority of more than 130 transcribed interviews that the committee has conducted to date. Even refused to provide copies of the audio and video files of the transcribed interviews and depositions.
Is there a unanimous consent request in here?
There is.
Okay.
I ask unanimous consent to enter into the record all of the transcribed interviews that the committee has conducted this Congress so that we can bring that real transparency to the American people.
I object.
Gentleman from North Carolina objects.
And I thank you for releasing the one transcript.
We will
Nina
release all the
Jagoff,
transcripts when we
well,
complete our
one day after I
investigation.
asked for it, you did
They've
release
completed their
Nina.
investigation. They won't give us all the evidence. We will give all that evidence when we're done with our investigation. The gentleman from Pennsylvania is right.
Thank you.
Attorney General Garland, over here.
Thank you.
Thank you for your long-standing and honorable service to our country and for being here today. The American people appreciate the serious work that you and the dedicated members of the Department of Justice do on their behalf every day to protect the rule of law and to protect our communities and our civil rights. Congress, of course, has a legitimate duty to oversee the department's functions, but it's pretty clear from the remarks we've heard from our Republican colleagues in this hearing that they have not brought us here today in pursuit of that duty. Instead, this hearing appears driven by the desire to curry favor with the disgraced, impeached, indicted, and now convicted former president and their ongoing efforts to legitimize his attacks on American elections, our judicial process, law enforcement, the press, and basically anybody who contradicts or seeks to hold him accountable. So this isn't legitimate oversight. It's political theater, and it's pretty bad theater at that. It's not the serious work that the American people should expect us to do here, and it distracts from our understanding and oversight of the Department of Justice's important efforts to protect our national security, to combat violent crime, gun violence, drug trafficking, and fraud, to protect voting rights and reproductive freedoms, to combat hate crimes, and to advance environmental justice. So I would highly recommend that anyone who is actually interested in the Department of Justice's work to read the statement that you submitted to the committee today, because it contains some important details about the work that the department is doing. I was particularly struck and profoundly troubled by your comments about the extraordinary rise in threats and violence against public servants in our country, ranging from criminal threats against election workers and members of Congress to the January 6th assault on this Capitol and our constitutional order. So I'd particularly like to focus on one aspect of those attacks on public servants, and one that has implications for the strength and future of our democratic republic. I'm interested in the Department of Justice's work to protect those who implement and defend our elections. Because in the wake of the 2020 election and in response to the lies and conspiracy theories embraced by the former president and his lackeys, we've seen election officials and poll workers across the country. These are apolitical employees, they're community volunteers, retirees, neighbors, civic champions. They've become targets for threats and violence when they stand up against the lies and seek to hold the former president accountable because they did their jobs running our elections. And to the extent that these lies and conspiracy theories have been embraced or elevated by members of this Congress or committee, shame on them. This isn't legitimate political discourse. It should not be part of our American public life, because words do have consequences. When leaders embrace misinformation, that's dangerous. And when they fail to defend our elections from lies and misinformation, that's dangerous and cowardly. Now, this committee has heard testimony from multiple witnesses, experts in election security, who've expressed concern that threats to election workers, which exploded in 2020, will result in fewer people being willing to serve, and whether as nonpartisan employees or volunteers. Attorney General Garland, can you comment briefly on the incidents of threats and violence against election workers, why these incidents are dangerous, and if you have any insight on what's caused this dramatic rise?
So your portrayal, I think, is quite accurate. I've been worried about this since 2021, and I've been talking about this with our United States attorneys. We created an election threats task force, particularly because we were so worried. And as you say, this is not only about elected election officials, not only about appointed election officials, but about ordinary Americans who show up as poll watchers on a single day during a year to run our elections. Our democracy can't work if those people fear threats that are urged against them, or if there's actual violence against them. We have brought, I don't have the exact numbers, but I think it's creeping up on 20 cases where there have been extraordinarily graphic threats of violence against election workers, and we have received some pretty strong sentences in those cases. Of course, we always balance First Amendment right to criticize to disagree, but when somebody makes a threat to kill an election worker, to kill members of their family, we respond, and we are going to respond aggressively. Every U.S. attorney has endorsed this position. Every FBI field office has an election security agent whose job it is to be sure that threats against election workers are investigated, deterred, and prosecuted.
Thank you. And if there are additional tools that Congress can provide that would help the department in this work, I'd appreciate hearing about it. I see my time has expired. Thank you for your testimony.
Gentleman yields back. The gentleman from Oregon is recognized.
Thank you, Mr. Chair, and thank you, Mr. Attorney General, for being here today.